Minnesota Workers' Compensation Court of Appeals is now in session. Both John Hamilton presiding.
Everyone have a seat. Morning, everyone. Morning. Are you Mr. Moody? I am. Okay. Nice to see you. Scully? Great. So we only have one case in front of us. The case of Olson v. Total Specialty Constructing. And I know both of you know the rules, so I'll just give you a quick reminder. We each have 15 minutes. Mr. Moody, you get to go first. You can reserve as much or as little time as you want. You don't have to tell me you're going to reserve time. Just keep track of your time on the clock there. And it's up to each of you to keep track of your time. If you do want to have a rebuttal, the marshal will put your name. Also, we now are live streaming as well as recording all of our oral arguments. The device sitting there on the table there helps do that. It will rotate toward the speaker. It'll be silent, so you won't know that it's moving. But it doesn't amplify your voice, and because of that, these things are not active. So outside voices, or as I like to call it, my normal voice, but for everyone else, outside voices, and that also helps the people in the back be able to hear you too. So with that said, Mr. Moody, go ahead.
Your Honors, may it please the court, my name is William Moody. I represent the appellants in this case, employer and insurer, Total Specialty Contracting and Federated Mutual Insurance Company. The facts of this case are very simple. The employee was a construction worker. He was on his way to a job site at the University of Minnesota campus, Lind Hall. As you may know, when they're doing construction at the U of M, there's often a perimeter fence around the construction project. That was the case here. The employee was walking on a pedestrian sidewalk that was open to the public. He fell in an unexplained fashion. This was 15 to 20 minutes before his first meeting of the day, and he was 5 to 10 feet from the gate in that chain link perimeter fence. It's the employer and insurer's contention that this injury did not arise out of or in the course of employment. Now, the record is fairly clear, in my opinion, that the fall was unexplained. According to our Diagnostic precedent, an unexplained fall on a flat surface is not compensable.
All right, so Mr. Moody, let me ask you about that. The employee testified, I slipped and fell. And he told us about all of the circumstances around what was happening, including the leaves and dark, not pitch black, but dark, and maybe some frost on the leaves. The compensation judge found him credible. In Dykoff, as I recall, the employee had some explanation for her fall, but the compensation judge found her not credible. Is this an unexplained fall, or just a fall that the compensation judge put it all together?
It's my contention that it's an unexplained fall. Let me explain. So the employee raises 4 circumstances in their briefing on this case in an attempt to note that this is an explained fall. 1 is the dim light. 2, the encroachment of the fence on the walkway. 3, the lack of familiarity. And 4, leaves. The employee did not state, I fell because of any circumstance. In fact, he repeatedly said he didn't know why he fell. Now, each of these circumstances were discussed to varying amounts in the record, and in none of them did the employee connect his fall to one of them. He simply was listing conditions at the time. Now, it wasn't only that he didn't say, I think I fell because of this. Okay, there was no explanation in the record for how these 4 relatively innocuous circumstances caused his fall. I would like to point the court to some precedent from this court in 2018. That was the Rosar, that's R-O-S-A-R, the Southview case. And it's a Dykoff case. The employee was a nursing assistant. She was almost at the end of her shift. She was going to punch out. She was walking on a flat surface, and she was hurrying, as nurses often do. She slipped, or she fell. The employee in that case testified she didn't know why she fell, but that she was hurrying. The compensation judge denied the claim, stating that the hurrying did not rise to the level of an increased risk under DICOP. It was appealed to this court. And what's important in that appeal is this court said, we don't need to decide today whether hurrying alone can be an increased risk. And the reason for that is the employee did not allege that the hurrying caused her fall. She also didn't connect her fall to the hurrying. It wasn't explained how the hurrying caused her fall. This court found that since that is the case, the employee didn't make the connection. The court can't make the connection and say that this is the increased risk when she doesn't make it herself. Now, I do want to discuss those four circumstances really briefly. One was the dim light. And as Justice Quinn says, the employee did testify it was dim, but that I could see. It wasn't pitch black, it was dark. I was able to see. He did not allege that he fell because it was dark, nor is it explained how darkness caused the fall. And the same arguments apply to each four of these circumstances.
Let me just stop you there for a second. So I think what you're saying, or the argument is, you can't say any one of the four. What about if you put the totality of all four together and not look at them individually, but in total?
I think the court can't do that. I think that there has to be a clear connection about what, because what we're looking for is the employee, whether or not the employee proved up a work injury, right? Under DICOP, you have to show an increased risk, special hazard. There has to be a line, there has to be an allegation that there is some connection to it. In this case, doesn't have it. If we look at the fence, that's alleged to be one of the factors here, okay? The employee was walking next to a chain link fence. At no time before his fall did he come into contact with it. He didn't brush against it, he didn't trip on it, he didn't dodge. There's no explanation for how that fence contributed to this fall. There's no allegation that he was constrained in any way by that fence. Yet it comes as one of the explanations for this injury. The lack of familiarity, that actually wasn't discussed very much on the day of the trial. The employee was familiar with U of M, not that block. But there's no discussion about, I should have known there was a hole here. I should have known there was an object. I wasn't familiar, and that's why I fell. There's no explanation like that with him. Now, the leaves are also important. Out of all these circumstances, the leaves are probably discussed the most. And the employee knew that the leaves were damp because the toe of his work boot was damp. But at the most, they were 1.5 inches deep. The employee had the opportunity to say whether or not he felt that those leaves caused his fall. He said, I'm walking, then down. And this isn't a cherry-picked quotation. This isn't out of context. This is consistent with his testimony throughout, that he did not know why he fell. That's also consistent with the medical records here, where they often provide contemporaneous facts. There's a description of the injury for the doctor. There's no explanation in the medical record for why the employee fell. Finally, there's no expert testimony opining on why or how the employee fell. The lack of this allegation and those facts that come with the allegation, the testimony of the employee providing facts that a work injury occurred, the lack of those means not only that there wasn't substantial evidence for the findings of work and that there was clear error, but it's my contention to this court that there's actually legal error because the employee did not carry his burden of proof. In fact, the findings in order.
Are you saying that the employee must be able to say with certainty, this is why I fell?
No, I am not saying that. In fact, that was noted in the respondent's brief, and I agree. He doesn't need to say with certainty. This isn't a criminal court where we need to have beyond a reasonable doubt. But there was no allegation whatsoever. And
well, didn't he say that I know you quoted the record correctly. I was walking and then I was down, something like that. There was another part of the record where he said, well, I fell, went over to the fence, pulled myself up, and I went inside to tell somebody I got hurt and I'm not going to be able to work today. But I assume it was the leaves. Is that not enough? And he didn't stay to investigate.
My recollection of that testimony is, the leaves were there. I don't believe in the record there's any actual allegation that it was the leaves. And I do think certainties are required, but there does have to be an allegation. And I would propose to the court that it has to be, it was probably the leaves, by a preponderance of the evidence. Almost similar to the standard for medical opinions here, beyond to a reasonable degree of probability. And I just want to say that the findings in order, they seem to make the employer and insurer here prove a negative, to prove that a work injury did not occur. Okay, but that's a total reverse of the burden of proof in Minnesota workers' compensation. Briefly, I do want to discuss, unless you have more questions about arising out of, I do want to discuss in the course and scope of. I believe that the proper legal analysis would be as follows in this case. This was before the workday, and it was before the employee was on the premises. So under the Minnesota statutes, this would be outside of the premises and therefore the coming and going rule. So I think the real question before the court is whether or not an exception, and there are many, to the coming and going rule, whether or not one of the exceptions applies. I would first note that no specific legal exception is noted in the findings and orders. No specific legal exception was alleged at hearing. Regardless, it appears that the best candidate for an exception here would be ingress and egress. And that exception applies when there is a hazard on the way in or out of work that's closely connected to employment where the employee injures themselves. The Supreme Court in Johansson v. Action Center, or Construction, explains the rationale. It's basically if the employee is coming and going from work and I'm quoting here, is exposed to a hazard causally connected with employment, the injury is compensable. This fails here for two reasons. First of all, we're not dealing with an icy parking lot. We're not dealing with steps on into a building. We're not dealing with an entrance. This was before the employee was engaging with the gate. We're simply dealing with a pedestrian walkway open to the public at the time.
So my question is, so if we look for a bright line rule then, when you're saying, had he been inside the gate, same circumstances, it would be, in the course and scope of, but because he's out on the public sidewalk and a pedestrian walkway that's open to everyone.
Yes, and I think there are several factors going in there, but in this case, if he was within the gate or engaging with the gate, I believe that would be on the premises. There was testimony at hearing that these construction workers are required to wear helmets, all sorts of PPE. He didn't have them all on at the time. And the reason he didn't is because he wasn't yet on the work site. So if he were in there, he would have the rules and regulations of the job site. I believe it would be. Perhaps the more important thing, though, is that there was no hazard that caused the fall that was connected to employment that the employee encountered on his way into work. With that, I would like to reserve 2 minutes if that's possible. Thank you.
It please the court. I'm Michael Scully. I'm here on behalf of the respondent employee Chad Olson in this matter. I'd like to start out talking about some of the facts that were discussed with the appellant. First of all, the PPE, the equipment. There's records saying that he didn't have his glasses or his gloves on before he entered the gate. There's testimony that as he fell, he was putting on his glasses and his gloves. Those glasses are tinted. This is 5:45 a.m. on a November morning. It is dark out. So I think that is something that is a distinction there. He was coming upon the entrance and was putting on his equipment to get in. The other issue, just on the facts, I think that the substantial evidence here, supports the judge's findings. This court has addressed arising out of and in the course of, in many cases, it seems, and it seems that there's some distinctions, but the arising out of the causal connection. Let it be clear, the facts are very clear. And my client was instructed to go to the University of Minnesota to work on Lynn Hall. This was a construction project. It was not open to the public. It was a construction site. He was told to be there at 6 a.m. He was instructed or recommended where to park on the Washington ramp. First day on the job, he'd been to the U of M campus. We all been there. He was never there before. So he parked in the Washington Street ramp and said, just kind of walk between Amundsen and the Keller buildings, and eventually you'll see a construction fence, and then kind of just look for the gate. You'll see it. Well, it was dark, and we all know it wasn't sunrise. It wasn't dawn, as indicated in the appellant's brief. It was dark at 5:45, and it's not in the record, but the sun doesn't rise on a November morning until approximately 7 a.m., so it was pitch dark. There was no light. In questioning, he said there was ambient light, maybe lights on in an office, but there were no street lights, no lights to lead the way. There was no light at the entrance to the construction site, not a street light, not a temporary light that allows persons to see the door. Like if we entered here in this building or anywhere where we all work, there's a light that kind of, says welcome. You can see that. There was none of that. So when you look at that, Judge Bauman found that by the preponderance of the evidence, this arose out of the rising out of was met. And those things were, it was dark. It was not yet sunrise. It was not dimly lit. It was dark. And there's testimony. The judge allowed questions in the transcript. You'll see, was asked numerous times about, was he able to see? He finally said, the darkness impeded my sight, my vision. So he could not see. The other thing is that the leaves, it's dark out. He came upon these leaves. It's the fall of the year, and they were frosty. 1.5 inches. Well, what is 1.5 inches? Well, 1.5 inches is about that much up from my finger. So, and he didn't say it was over his boots to the top of his boots, but that was another factor. Then there's the fence. There's a construction fence that was encroaching on the sidewalk, and there was how much it was encroached upon or not. Only my client knew. There were no actual photographs taken during, before that or after. And finally, he was unfamiliar. As I said, this was the first day on the job. He just didn't say, they said, go to Lynn Hall. He said, they told him, you need to go there, you need to be there, and this is how you're going to get there. So that part of the argument, I think, arising out of has been met in this place. In the course of time, place, circumstance, in the incident that caused the incident that caused the injury, Chad was instructed, or Mr. Olson, excuse me, again, he was instructed where to park, where to walk, what to look for, not to go to an address. It's kind of like, put that on your, you don't have an address, so you put it in Google to get a Google address. which you have in foreign countries, and I digress there. But there was no address. It was kind of by vision. Go here, go there. And then when you get there, you're going to kind of see this place. So it's dark. He's kind of wandering around. I don't want to say that he's blind, but it's unfamiliar territory to someone. And he's there, and this was the only entrance. As the testimony shown, Lynn Hall was the only entrance because the other entrance on the construction site was not open because of asbestos abatement. It was the only place where he could enter. So that's that. And the final thing is meeting and arising out of is he was doing it for the betterment of the employer. He was instructed to go there. He wasn't detouring, but he was there on behalf of the employer. He was on the U of M campus, go to Lynn Hall, perform an insulation duties. He's a journeyman insulator, and he was told to be there. Be there before 6 a.m. He got there at 5:45. We all want to be there and early. We don't want to come right at the time. We all want to be there early. He's a dedicated person. He even testified to that. He wanted to be there to get the instruction. Then after that, from the foreman, from a general contractor, another contractor, Horowitz Construction, and then pick up some deliveries, meet some deliveries, and do the job that he was supposed to do. So, but as a matter, that is our position that in the course of is satisfied here. Now, the ingress-egress rule, there's a question that he wasn't in that. I think when you look at the whole case where the court said that even though the employee was on a public sidewalk when she slipped on the ice, she was an employee, not that she was she was on the public sidewalk as an employee, and that I think talks ingress here. The same in this case. Mr. Olson was there because he was doing his duty. He was a heat and frost insulator. And it's not just one factor, it's the four factors with the preponderance of the evidence. We don't need to just have one thing or one allegation that needs to be made. The Judge Bauman took the preponderance of evidence of all of the facts. Dimly lit, it was dark. There was no entrance saying, here's the construction entrance to Lynn Hall. And I'm not trying to be sarcastic, excuse me if I raise my eyebrows.
Mr. Scully, I do have a question about this. I'm most troubled by the cause issue.
Okay.
Because he denies over and over again, he doesn't anything that was proposed to him. Did the leaves cause? Well, I don't really know if the leaves caused fire. I don't know if the fence caused. He doesn't know. He doesn't know how he fell. So how is it then that these four factors prove that he fell in a situation that arose out of his employment?
He doesn't know, but when you add all those four factors by the preponderance, not certainty, by the preponderance of the evidence, is how he fell.
But if he doesn't know if the leaves affected him, he doesn't know if the fence encroachment caused him to fall, he doesn't know if the unfamiliarity of the situation caused him to fall, or that it was dark. He doesn't know any of this. How can the preponderance of the evidence show that he fell as a result of his employment?
He said that, number one, getting back to those four factors, that his vision was impaired. So is the vision impaired? He may not know. But the fact finder, the judge, by the preponderance of the evidence pursuant to the statute, found that these four factors is cause for the injury to be compensable.
Right, so let's follow up on that. I think we asked Mr. Moody this already. Can a compensation judge say, well, I know the employee said, I don't know. I can't even say probably one or more of these factors, but I, the compensation judge, can put it all together and come up with probably. Can a compensation judge do that?
Yes.
Okay.
That the compensation judge is the finder, is the determination, makes that determination. That's the judge's duty.
And if I'm paraphrasing everything correctly, Mr. Lee, correct me if I'm back up, but as I understand it, his argument is If the employee can't even say probable, then the compensation judge is committing an error of law by putting that all together. So respond to that.
Say that.
If the employee cannot say it was probably one or more of these factors, then the compensation judge is committing an error of law by going that far by saying, well, it probably wasn't.
No, no. He said, he provided the facts and the judge made the determination that based on the probability of these facts, that the injury was caused while in the course and scope of his employment. So you look at with, you know, he didn't know. And it says, when he testified, he said he felt kind of funny, kind of ridiculous. He didn't know. But the fact of the matter is that his boots were frosty. It was a November day. Leaves were wet, slippery, and he fell. And the fact is that it was the rising, as I've outlined, the rising out of the course and scope had caused this injury. And again, with as far as ingress and egress, he was approaching in full. They said that the slipping on the ice. I think I'm repeating myself. That he was there as an employee, as Holt was an employee as a painter.
I think Mr. Moody's argument on Holt is that at least in Holt, the university was responsible for upkeep of the sidewalk, whereas in this case, this employer, it's not the university, even though it's the university, it's campus. The University of Minnesota is responsible for the sidewalk, not this employer. So does Holt apply then?
This Holt still applies, yes, because with implying that the university, you know, that the employer is not responsible, then you're getting into the whole argument of whether it's you know, common law negligence, and that's not the standard here. Work comp, as you know, is a no-fault system, and it doesn't apply to work comp. It's the employee's recourse is workers' compensation benefits when he is injured while arising out of in the course and scope of his employment. And in saying that is, again, he was instructed to go to the U of M campus. He was instructed to go to Lynn Hall. He was instructed to go to this construction site to perform certain duties, and that was to do insulation as part of the remodeling of the renovation of Lynn Hall. And that instruction and request was provided by the employer and was for the betterment of the employer. So that's my distinction between, you know, common law negligence in a third party claim versus work comp, because I've always treated it as a no-fault system. So some other my client did testify, he slipped and fell. We were asking earlier, what's the cause of this? He slipped and fell. And there's talk of Dykoff here. Well, Dykoff is on a flat, clean surface. The client was in a dark, leaf-covered area, frosty leaves with no light at 5:45 in the morning as he was approaching this construction entrance. So there's a distinction there. Unexplained facts, Justice Sundquist, you kind of, you know, what's the unexplained facts? I think you take the facts in totality, is that he was that all of it, this caused him to fall. And why did he fall? Because he was there on behalf of his employer on that morning. One final thing that this is fine. I say the final, but I probably have something more to say. But to talk about it in the medical records, the medical records are hearsay, and I don't have the site for that or the case for that. But medical records are hearsay and can't be relied upon as far as specifically how an injury occurred. Just wanted to, just made note of it. So, and with that, my time is up.
Thank you, Mr. Stone.
Thank you. I quickly want to address some of those facts. With respect to the glasses, I don't believe that the employee was putting them on or fiddling with his PPE. In the transcript, he's asked, "Did you start to put on your safety glasses?" He responded, I don't recall. The leaves, it's our contention, they were not frosty. Within the record was proof that the temperature that night was well above freezing. I believe it was in the 40s was the low. At the time of the injury, it continued to be well above freezing. Lastly, the employee did see. He did testify that he could see. He's, in quote, "I could see." And he also testified that there was some permanent lighting around the area. This talk about the employer sent him there, the job was at Lindholm. I think we're straying towards a positional risk test argument there. And I do discuss this briefly in my brief, but that's not the law. The law is that the employee bears the burden of proof to show that there was some increased risk or has, for Justice Quinn's discussion of can a compensation judge connect the dots for the employee? Can there be a number of circumstances which could have contributed to a fall, even though there's no allegation that it did? Can the judge carry the employee's burden of proof, make that allegation and connect the dots? And I would submit that they cannot. I would once again point this court to Rosar, where this court didn't need to make those decisions because the employee failed to allege that increased risk actually caused her injury. Thank you.
Great. Thank you both. The record is now closed, and we will issue a decision within 90 days. With that, we are adjourned. Thank you.
Rayus?